to the Indiana State Board of Nursing, Thursday, August 20th, 2026. We will establish quorum. We have Nancy Youngst, Dr. Pearson, Jessica Harlan York, Angie Morris, RN, Jennifer Miller, RN, Rita Major, LPN, Dr. Seago, and me, Jason King. So we have 8 members seated this morning. And moving forward to the adoption of the agenda, everybody had an opportunity to look at it. Any additions, discussion?
There were 2 changes, I think, to the agenda. So under the final hearing, number 13 has been continued. And then under the pre-hearing settlement conferences, number 1, Robertson has been.
Okay, so that was final hearings number 13, Brandon Davies. It's going to continue. Sharice Robertson, yes. Okay, any additions? Discussion? If not, can I have a motion?
I make a second.
Okay, that's Morris Miller, all in favor? Opposed, abstained, motion carries 8-0. The adoption of the ALJ recommendations from July 16th.
We need to have a conversation on one. Kayla Evans. Kayla Davis. Just kidding.
Let's take your review.
Is going to be entering a play agreement. I'm assuming court supervision is a part of that. I'm okay with the recommendation as it stands. I just believe that it sure is a bit from what we've done in the past. So if we're trying to be consistent, I think we need to at least list some indicators for that, which I wasn't in that meeting in this paper. I believe obviously isn't going to listen to that today. I don't know how bring this thing, but I know that we've rejected items like this before.
But just for newer board members, the prior precedent, generally speaking, if somebody has any criminal matters that are pending, generally it's it's all, for this one, it's not a review, but it's the ability to test, and then we refer it up to the Attorney General's office so that they can follow the case. And then if there's anything that, criminal case goes forward, they're able to do things and have the ability to bring it back. So that's generally what we do. As Morris is speaking about precedent. Only question a lot of times on these is what's the timing, because we don't have like 180 days to see this through. This is one of those that's going to come up against the timeline, so if we reject it, but we go free and clear anyway. Do you know?
Which one are we talking about? What number?
So it's Kayla Davis on personal appearances from July 26th. So 1 month ago. The very first PA.
Number 1, Kayla Davis, right?
Correct.
And we're worried about the 120 days to consider her application.
Correct.
I guess we need to know the day she submitted, whatever the date is of the application. That's what would tell us. Which time we have to play with.
Because by the time she gets rescheduled and all of that, it'd be possibly going to make some headache.
Correct.
I would say generally those things can be close because by the time she submitted the application, it was scheduled. This is August, so she's not going to figure it out. She'd be September. We got to 3 in October, so I'm going to guess it's going to push it no matter what the application comes. It's tough.
Sorry?
No, I was just thinking the timeline, it would
Yeah.
probably be October before we'd be able to vote on the recommendation. Probably not anything we can do. We can't modify it. Yeah, we can't send it up to the AG afterwards.
You could read,
If we reject it now, my problem is it's by the time it's gonna bump up against the 120 and she's gonna go through there anyway.
I'm stuck with it.
It is a precedent. For further review, or if it's a known thing that's not closed and taken care of, then we issue different information.
And with that, I think it's just, if we have some indicators, it would be helpful to know, like, how we got here. Like, I'm okay with that, like, but I want to know how we got here and just, if we are going to do something different, that we know the why behind it. So I'm not necessarily like an outright, like, not okay with it. I just wish that the minutes reflected how we got to this recommendation, and if there were any mitigators, I'm assuming she was transparent throughout the process. I'm assuming it was a relatively low behavioral, but all of these things we didn't know. She probably been a stoplight. Was she by herself? Like,
Could you refuse it and follow the precedent and then just let it turn out because of time, but if we were following the precedent?
And the outcome's the same,
Yeah,
like, it's pretty.
But at least it shows that we followed our precedent.
that's
Let it get thrown out because of time, not because we agreed.
a good thought.
So you're missing the analysis of why we
Yeah.
skip the precedent and went out to.
so, we're saying we issue her pretty clear.
Yeah.
That has not been what has happened in the past.
Yeah,
There may be circumstances where that's appropriate. I don't see that reflected in the minutes that we have in front of us. So since none of us were in the room, I don't even know, it didn't even state if this was her only encounter with the legal system. We don't really know any of those things. So what appears to be a simple OWI, like handed in the plea, could be a much bigger issue. We just don't have the context for that.
yeah, and the precedent would have been to issue her the license, but at the same time, refer to the AG's office for
Right.
further investigation, because her charges were still pending in.
Or. So from a standpoint, so let's say that we deny it, as Ms. Majors has suggested, understanding that it will bump against the 120, do we know what that looks like as far as? Not to throw you a curveball.
Thank you, it's supposed to be nice to me.
I think we would update it in her file. Right, and I'm not exactly sure.
The outcome would remain the same, but at least for our purposes, like just in case that we can deny it, at least to say that we. Because the circumstances, the minutes are unclear.
And that document, anything that she submitted with her application, it's already in the prior review, so.
All right, so Ms. Morris, what do you think?
Oh, I guess motion to deny Kayla Davis.
I'll second. Thank you.
So we have Morris Majors for denial on Kayla Davis. All in favor?
Aye.
Opposed? Abstained? Motion carries 8-0-0. All right, how about the rest of them?
Make a motion to approve.
Second fingers.
So it's a motion to approve numbers 2 through 16 by Ms. Miller, seconded by Ms. Majors. All in favor? Opposed? Abstained? Motion carries 8-0-0. Moving on to the ALJ recommendations for August 6th.
Have a discussion point, but I made the motion, but it's on, reinstatement number 1. reinstatement number one, it is,
And the lessons that you learned at college.
yes. So I had, I want to make sure the wording is in the way that I'm intending it to be, and I've read it multiple times, over the last couple of days, I'm not for sure that it does, but, this respondent is on the OIG exclusion list. And so her ability to work is limited. And so the length of her probation, we have typically done around an active practice setting. And the setting that I would prefer for this respondent would be in medication administration. And so her intent is to either work remotely or at plasma center. And so we tried to craft a recommendation that would have her on probation for either one, if she's working remotely for the length of her RMA, because her RMA is for 5 years, she has to be compliant and successfully complete her RMA before she can come off of probation. So she'd be monitoring and have drug screening. Or if she's had 12 months of active practice in a setting where she gives medications. If she comes off the exclusion list, if she works in a setting,
So it's an either or.
it's, I know I'm one of the ones that's very, active practice driven. I'm trying to create an environment where we can monitor her safely and there's still the ability at some point.
So how would you like it to read then? Is it just a matter of the
I guess my,
to remote setting or with required proof? Or how does that read?
yeah, I think I said, 12 months of active practice in a setting with medication administration, or active practice in a remote setting and fully compliant with our RMA until completion.
Was that an and?
Well, it's active practice for 12 months where she delivers medications, or active practice and successfully completing her RMA, like in a remote setting. And I don't know that this reads that way, but I don't know if you guys are reading it, you have that way, or do you even agree with it? But
Well, the way I just read it and the way you just said it. This says, or successfully completes farming or conditioning. So I heard you say and completes her. But it'd be 3 months, right?
so the first option is to work remotely
Right.
and do the 5-year RMA and be fully compliant. The second option is if she's working, giving medications, she can petition to come off within 12 months
Yep.
and be fully compliant with her RMA, but she doesn't have to complete it.
Gotcha.
Does that make sense?
Mhm.
Okay.
And I think that.
Yeah.
And I also have mitigating and aggravating factors in there, and neither are listed. So for mitigating, she has a plan, she's in therapy, she has a support system, she was transparent. The aggravating history of previous, non-compliance and substance abuse.
Yeah, can I ask a question? What would be the reasoning for not having successful completion of the RMA on either side?
I felt like we've allowed people to come off of probation if they've been compliant with their RMA for 12 months, and we've been able to see that they can practice without issue with the quarterly reports. And then they still have to continue their RMA, but they can come back before us if there was a reason, like that's not felt that they were being non-compliant. So, I mean, I'm not
That's my
opposed.
thing is like, if she was already not compliant in the past, like, that's how I understood that she has previous non-compliance, so. I don't know. Just something to think about,
You would say she'd have to be on probation for the 5 years regardless, or longer if there's like extensions.
again, not being in the room, I trust your judgment, so if that's the thing that you feel comfortable with, I'm fine with it. I was just curious if there was like a. With the RMA, just giving her history of non-compliance and issue.
I mean, we've done both. I think I was thinking about those, if we allow those, some compliance. I'm not looking at it. But I don't have an issue with it being full farming.
I don't know where everybody else stands. It's not a make or break issue for me, but I agree. I think we should list the computers. You're right.
And then is there a way to rewrite that so that it states it as or has requested? I'm talking about when an order was issued for the reinstatement.
Yeah, I think Kyra Washington might have been Katie, but she sends me copies of everything once she's finished before she sends it to PLA clerk. So I should have a copy of it somewhere.
I think we're talking about the reinstatement.
Sorry.
You said Kyra Washington, I think we're talking about Miranda, the reinstatement.
Yes.
Under reinstatement, that rely on Miranda on. It's down,
At the bottom.
yeah, further under the two for one under reinstatement.
And the comment. Yeah, that is also Katie, because I did Courtney Door, we split them up. She didn't ever want to do it too. I should have a copy of that too. Or if not, and she hasn't finished it yet, I can definitely reach out to Katie and say, let's talk about this one. As long as I have the notes as you, what you intend the order to say. Ms. Moore.
Yeah, I stated it. I mean, do I need to?
So here's what I wrote down, that it needs to be modified to say that she can be 12 months of active practice in medication administration and be compliant with the RMA before petitioning to come up, or an active practice with successful completion of RMA prior to coming up. And then mitigating factors were that she had a plan, she was in therapy, she had a support system, transparent, and forthcoming with the information. Aggravator was previous non-compliance and substance abuse.
Yeah, I think we need to add the words active practice with medication administration.
And that's the second.
Yeah.
Well, no, she got that one in the first part.
And then
It's the
remote.
second part.
The remote area.
But I mean,
If she's able to find a job where they will allow her to be in because she's on the IQ list, if she finds that, then she'd be able to active practice come off, or petition to come off of
If she-
probation. If she does like active practice, like normal as normal nursing, with 12 months and compliance with ICAP. If she's not able to, she can continue in that remote setting, but she has to maintain that in full 5 years of the RMA.
yeah, but I mean, we can talk about the semantics of the wording, but if we don't agree, then maybe we could, I mean, if we go back to review anyway. But
Yeah, anybody else have any objection to it? So I think as long as we update the wording on the order. So,
Sorry, Ned, I can send you what I
Okay.
wrote down.
all right,
Okay.
so with that being said, assuming we can modify this so that it reads as intended, anybody else have any other thing to discuss on the ALJ recommendation for August 6th? If not, do we have a motion?
Motion to accept all recommendations for August 6th, except number 1, reinstatement of Miranda Khan with the modification.
Yeah, the amendment to All right, so we have a motion from Ms. Majors. We have a second. Dr. Pearson, all in favor? Opposed, abstained, motion carries 8-0-0. Moving on to the adoption of the minutes for July 16th. Understanding that we'll need to make that modification for
Miranda Khan.
for Davis on that. On the 16th, July 16th is for Davis.
Yeah, Shannon Davis.
Yes. Outside of that, are there any other discussions, changes that need to be made on the meeting minutes? If not, go ahead, motion. Morris Majors, all in favor?
Wait,
Aye.
there's another one.
Oh,
It's okay.
all right, we'll try that again. Morris Miller, all in favor?
Aye.
Opposed, abstained, motion carries 800. All right, moving on to the minutes of August 6th. Outside of the change that needs to be made for the matter of license of Miranda Khan, any other additions, deletions, discussion? If not, do we have a motion?
True, Lawrence.
Morris Pearson, all in favor?
Aye.
Opposed, abstained, motion carries 800. Moving on to the adoption of recommended orders. Any discussion on any of these? If not, we have a motion for 1 through 13.
Motion to accept adoption of recommended orders. 1 through 13.
A motion by Ms. Majors,
Second.
second by Ms. Miller, all in favor?
Aye.
Opposed, abstained, motion carries 800. Moving on to education, we only have one. It is an FYI only, South College and Office of Resignation of Alicia Carter, RN, as Associate Dean and Program Director of Nursing, effective 8/7/26, and the appointment of Dr. Tanya Marie Paget to that position effective 8/31/26, and CV is attached in your packet. Moving on to our ISNAP report. Good morning. All that can happen. Would you like to give us a verbal report?
We have a total of 309 active participants, completed 8 intakes in the last 30 days. We actually had a pretty great milestone. We have discharged 14 people in the last 30 days. 7 of those, however, were successful discharges. So we're pretty happy that those numbers are going up. We currently have 35.1% people in medicated assisted treatment RMAs, 64.9 are non-medicated treatment RMAs, and Adderall, pardon me, Adderall remains our top prescription positive. Those are the highlights, unless you'd like to give all the sound damage by me.
Any questions for Ms. Trout? Thank you. Director's report.
Yes, I should have that here, here it is on SharePoint, there's a quick snapshot of license type applications. I assume this is pretty normal, so forgive me if I'm talking about things that audio doesn't normally talk about. She did want me to highlight a couple of things. The average processing time for new applications is 3.24 days. The 2026 LPN renewal numbers, right now, 2,493 out of 22,083 have been renewed as of the 18th. That's 11%, it's still October 31st deadline. And then a couple things about education. They've had 1 capstone presentation and 3 initial accreditation visits and 2 one-year follow-up visits.
Come here. However, they did make some changes to the COC process, and having a defined email and feedback I received was that process ran very smoothly. And we can see on the average processing time that it moved quickly, so much appreciated on those changes. So just to them.
Report, this is just, I want to make sure I'm reading it right. Under RN licensure, Kind of active with the communities, we're down almost 35 minutes.
I would assume yes. Yeah. And moving forward to proposed settlement agreement. Ready to have any conversation about these?
If not, I'll make a motion to approve the proposed settlement agreement, starting with number 1, Lord Sullivan, through number 9, Lisa Campbell.
We have a motion from Ms. Miller.
A second.
We have a motion from Ms. Miller, seconded by Dr. Siegel, all in favor?
Aye.
Opposed? Same, motion carried 8-0-0. Next, we have motion to stipulate. Won't have any oral argument on this. This is just for us to discuss. Wonderful. If you have any conversation, anything would like to discuss, motion to stipulate.
Is this something rare? I don't think I've seen these before. We don't get them often.
Yeah.
I haven't seen them, but maybe.
Yeah.
If any,
And a lot of times in like the pre-settlement hearing processes, they stipulate to the facts, but we don't necessarily hear it or rule on them. It's something that takes place that they agree that, yes, these things happen. But generally doesn't come to us to rule on the motion, if that helps. So it does happen often, just not immediately. Any thoughts on this? Anybody feeling one way or the other? Any discussion about it?
I could go either way with this one. I mean, obviously, if they're gonna stipulate, like, that seems pretty easy. The state objecting to it, so like, is there a piece of this that is important to what? Obviously, there's a piece of this that is important enough to cause the state to object. So do we want to hash it all up? Do we want to see all the things? Or are we going to accept the stipulation? I just have some hesitation in, a lot of these are bigger than we agreed to the facts. So, I don't know.
I just want to clarify the question from council before we continue. So the idea is that the respondent would stipulate to all of the facts, but that doesn't mean we don't get to see the evidence. Is that correct? The evidence would still be like the exhibits. We can still see all of that. Is that correct or not?
I'm not sure about the presentation of the facts, and I think that the hearing would be transferred into just a hearing about what the sanction should be.
Okay,
Yeah. So we wouldn't.
so we wouldn't see that.
I don't think you would.
I have the same question, because I feel like it went back and forth between their objections, and one was saying, yes, you can still present yourself. It's not. That will still be.
If I could add also, this seemed, the initial motion to stipulate seemed very unusual to me. Stipulation is usually an agreement between the two parties to the dispute,
Said that.
not being part of the fact to make the other person essentially stipulate.
That's what I don't understand, either agree with it all. Why do we have to?
Right.
Well, I think.
If they can
So-
stipulate to the facts in the hearing.
We don't have to, we don't normally respond to that, right?
It's usually something they agree to together and
Yeah.
present it to you completely.
And if they don't agree,
They
they don't.
they-
agree.
They essentially vote together.
There's
Yeah.
a reason they don't agree, so they're not
Yeah, that's-
stipulating.
But then we might, if they don't agree, stipulate, there's nothing to.
Yeah,
Just make a motion to do this.
Yeah.
If you're on board, cool. If you're not, that's okay. There's something about it that brings me pause.
And if you. I don't understand what we're, we don't normally, like, they stipulate ahead of time. And you don't ever get involved, so why would we get involved?
Yeah, from my reading, and I don't listen to it, I'm just trying to play this out a little bit further. It's just the fact that I think they're trying to stipulate to, yes, we agree, the state has brought up these concerns or these allegations or what have you. We agree with all of that, so there's no need to hash it out as far as testimony is concerned. I think that is what council is trying to drive toward. I'm not trying to sway anything, I'm just trying to say that's what I believe that council's trying to go to. Just that she lived through it, she did her time criminally, all of that stuff. Yeah.
I don't think there's anything. We don't have to be involved in that. I mean, it's, they didn't agree, move on, right? And that's how I would see it legally, but.
I think most of the boards lean one direction. So. Everybody feels along with Ms. Morris, is that correct? I want to be out here.
I don't, I can go there, Brian.
All right, so Ms. Morris, you were making a motion.
And I need a motion to deny.
Okay, we've got Morris, right?
I'll second.
Seconded by Ms. Marley York. All in favor?
Aye.
Aye. Opposed? Abstained? Motion carries 8-0-0. Have our pre-settlement hearing process scheduled for the last meeting.
Is it?
Do you have the parties here? Pause just for a second. She checks to see. Rude, rude. All right, moving forward in the matter of the license that Caitlin inherits. We can go ahead and swear in our court reporter, please. Will the official reporter designated for this hearing please stand and be sworn, raise your right hand and state your name?
Jessica.
You solemnly swear that you will keep complete true notes of all that transpires in this hearing, prepare a complete transcript thereof from your notes and faithfully perform all the duties imposed upon you as an official in favor of the laws of the state of Indiana.
I do.
This is an administrative hearing taking place on August 20th, 2026 in Conference Center, Indiana, Government Center, number 32 West Washington Street, Indianapolis, Indiana, 9:10 a.m. local time is being conducted pursuant to the laws of the state of Indiana, as found in Indiana Code 4, Article 21.5, before 7 members of the Indiana State Board of Nursing and a cost document is administrative cost number 202503 NUR 0044. The respondent's name is Caitlin Parrott. Notice was provided to the respondent in the Attorney General's office as provided by law on August 14th, 2026. This is the hearing to determine whether the respondent's license should be summarily suspended based on the state's petition for summary suspension filed on August 14th, 2026. My name is Jason King. I'm serving as hearing officer for the board. The following members of the board are seated with me: Nancy Young's LPN, Dr. Pearson, Jessica Harlan, York, Jennifer Miller, RN, Rita Majors, LPN, and Dr. Seto. At this time, I request that any board member who believes that he or she cannot respond to a fair hearing and render an impartial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to the public, being streamed live on the internet, and is responsibility of the party to counsel to ensure any protected health information or other confidential information necessary to the parties' case and chief be identified prior to disclosure. Failure to properly protect patient information could result in rejection and exclusion of testimony of the witness. May we have appearance of counsel, please?
Yes, Tim Fox, Deputy Attorney General for the state.
All those know themselves to be witnesses and may be witnesses in this cause, please stand and raise your right hand and be sworn. Do you solemnly swear or affirm the penalty of perjury that the testimony you're about to give in this cause be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. May be seated. The parties in the matter hereby notify that the board will take official judicial notice of this file and record in this matter. Do you have an opening statement for us, sir?
I do, sir, but before we begin, I received a email with an attachment this morning from respondent Caitlin Garrett. She wanted the board to read her statement. I had sent, as soon as I got it, I forwarded it to the clerk for IPLA and also Ms. Racine, but she's not here. So I also just forwarded a copy to Ms. Osborne. I didn't know if it was possible for that to be viewed by the board.
Send it to the county and you can put it. It's in here in document.
I have no objection if that, for that to be admitted.
I would say that it's an exhibit on the other respondent, is that you're.
I'm sorry?
Yeah, if we should admit it as an exhibit or just read it as a document as testimony, I think it would probably.
Yeah, since there's no one here to submit it as their exhibit, yes, just.
Yes.
Okay.
So would you like to read it and so it's on the record, or do you want us to read it separately?
It's 2 pages, so didn't know if you want to read it. Might be easier to read it separately.
Can you please speak into the mic drastically?
Yeah, sorry. It's 2 pages long, so I didn't, might be easier to read it rather than I can read it into testimony.
It's still. I see the email.
It's under, so here in the SharePoint. Under her file, it's under the hearing documents. That should say.
It's just.
FW.
That's just the
There's no
email.
Oh, there's no attachment.
Yeah, there's no attachment, sorry. Yeah, the email is there, but just not the,
And we need the PDF.
it just says. I don't think it's anything.
Yeah, you're right. I'm sorry.
That's right.
Refresh, it should be.
Yeah, it's there. Thank you.
Should we proceed with the opening statements and when it comes time for the respondent's case in chief, then to present the statement or?
Sure.
Mr. Fox, you can continue with your statement.
Thanks, sir. In this case, Caitlin Parrott, the nurse in question, was ordered by the board to undergo evaluation of ISNAP in November 12, 2025, in its final order. She was then enrolled in an RMN with IPRP. The reason for her underlying conduct was drug use, specifically cocaine. She was found unresponsive in a hospital bathroom, and she had a rolled up dollar bill with white powdery substance tested positive for cocaine. So she underwent an RMA with IPRP. However, during that RMA, she exhibited significant drug use, including cocaine, meth, benzodiazepine, and marijuana on multiple occasions, and also alcohol. And she also had several missed check-ins. She was unsuccessfully discharged, and she's not currently being monitored which is why the state is asking for a summary suspension. State is ready for their evidence. State would call Tracy Trout. Ms. Trout, could you please spell your name for the record?
Tracy Trout, Tracy,
Thank you. And what do you do, Ms. Trout?
I'm the program director for the ISNAP program.
And what are your responsibilities in that regard?
I manage a caseload, I manage 4 case managers and, basically in charge of making sure policies, procedures, and documentation is handled properly.
Are you familiar with Caitlin Parrott?
I am.
And how are you familiar with her?
She was enrolled in an RMA, in the ISNAP program.
When was she first enrolled in that one?
Her RMA began May 15th, 2025, and she's unsuccessfully discharged by 5/29/2026.
Did you prepare a report that summarized your involvement in her RMA and the
Yes.
reason for her discharge?
Yes,
Okay. You're confident you testified today, correct?
I am.
I'm going to show you what's been previously marked State's Exhibit 1. You recognize that?
I do.
And what is State's Exhibit 1?
State's Exhibit 1 is the consumer complaint that I filed on Ms. Parrott.
What was your reason for filing that consumer complaint?
On 5/15/2026, our DEF enrolled positive for cocaine. We sent several messages requesting an explanation and to speak with Ms. Parrott. I should back up and explain that our process is when we have a positive drug screen, we have a dilute or value out of range, we contact the participant immediately, and that is every participant, no exception, because we want to have immediate contact about those results. She kept saying she was going to call back. She kept saying she was busy at work. We received another message that stated that she accidentally slept all day until after we were closed, and we were having a great deal of difficulty, getting her to respond to us. She kept saying that work was nonstop. She couldn't get a break. When she was off, she was sleeping. And at that point, I made the decision to file the consumer complaint, and I filed an OTSC along with that consumer complaint and filed it with the IPLA.
When you say no TSA, when you filed an order to show cause?
Yes,
Okay. And what you're looking at is Exhibit 1, that true and accurate copy of the complaint you filed?
it is.
State would move to admit Exhibit 1.
State's Exhibit 1 admitted into evidence.
And Ms. Trout, that's not the first complaint you filed in her case, correct?
No, that was the second consumer complaint.
Okay. I'm going to show you what's been previously marked State's Exhibit 2. And can you identify that for me?
State's Exhibit 2 is the order to show cause notice that was filed, no action needed with IPLA, and filed in with the consumer complaint.
And the State's Exhibit 2 also, is that a summary of her behavior in her RMA?
Yes,
Did you prepare that?
Brianna Foster prepared that, and I reviewed it.
Okay. And is that a true, and Brianna Foster, she works with your office?
She's a clinical case manager.
Okay. Is that a true and accurate copy of the report that she filed?
It is.
State would move to admit Exhibit 2.
State's Exhibit 2 admitted into evidence.
We previously stated she first, Ms. Parrott, first enrolled in her RMA on May 13th. Looking at page 1 of State's Exhibit 2, the IPRP report, how many missed check-ins did she have?
6 missed check-ins.
I'm sorry, I'm looking at page 1. I think there's a different number on page 1.
She had 5 missed check-ins.
Okay, now page 1 lists 1 check-in, missed check-in.
Sorry, Tim. Yes, 1 missed check-in.
And then you also have more missed check-ins on page 3, correct?
And there were 4 additionals. That was previously, that is information that we included on an OTSC from a previously filed OTSC. So there were 4 more reported on that one.
Okay, so a total of 5 missed check-ins.
Correct.
And let's review Ms. Parrott's drug screens. On the first page of State's Exhibit 2, how many negative drug screen results or positive drug screen results did she have?
So she had a positive for cocaine and then 2, value out of range drug screens prior to that.
What value are the range that you got?
Value out of range means that the creatinine levels in the urine are off, and that could signify several things. It could mean, depending on the level of creatinine, that the urine has been adulterated. It could mean that also that the urine was dilute, depending on where that creatinine range falls.
Looking at the positive cocaine test, that was fairly recent, wasn't it?
5/15/2026, yes.
Okay. I'm going to page 3 of your report. I believe that was from the previous OTSC file. Let's look at her other positive drug screens. How many of those did she have?
She had a positive hair stat for THC, amphetamines, cocaine, methamphetamine, MDMA, and benzodiazepines. She also had another positive UBS for benzodiazepines, alcohol. She had both ETD and ETS, so that is positive for consumption. And she had another test that was positive for THC. And then she had another positive for MDA, MDMA, THC, benzos, alcohol. And she stated at that time that her drink was tampered with when she was in a bar.
On the dates of these tests, where she was positive for cocaine and ecstasy and meth and the others, were these all in 2025?
Yes, 5/28/2025, 7/21/2025, 9/9/2025, and 11/5/2025.
Okay, did Ms. Merritt have any other deficiencies in her RNA?
She had several dilutes. She had missing reports. She was missing reports from her therapist and her sponsor. We also had difficulty getting her monthly meeting records, et cetera, from her.
Looking at the bottom of page 3 in your report, it mentions that you suggested she go to intensive outpatient program for following recovery. Is that correct?
That is correct.
You know if she ever did that?
She did not. During her first RMA, we had a very difficult time getting her to get into treatment. She finally did attend some treatment. And then subsequent to that, when we started seeing a lot of positives again and some other types of behavior, we asked her to do that again and get into some kind of better structured treatment.
But she never did that.
She finally did attend an IOP that we think that she got something out of, but that was in her second RMA.
So you know what she did that.
Not off the top of my head.
Going to page 1 again of your report. This involves the last test she had for cocaine this May, about 3 months ago. What was her response? Did she ever provide an explanation on why she was positive?
We never received a response. When she was contacted by her clinical case manager, she kept saying, work has been nonstop today. I have yet to get a break. I am on a med pass. I will call you on my next break. Then she would say she didn't get a break. And then that's also when we were, several days after that, she responded again and stated that she had been off, but she'd slept until after our office had closed.
Has she contacted you since then to attempt to re-enroll in the Army?
She has not contacted us so much to enroll, but to explain that she was not, in her opinion, purposely ignoring us or refusing to have a conversation. More that she feels we were not being supportive of her work situation, and that if she was at work, that was more important that she was at work tending to patients than discussing her positive judgment with us.
Do you know where she was working when she had this positive test for cocaine?
She was working at a hospital in Fort Wayne, but I do not know the name of it. She has since informed us that she has taken time off work to concentrate on her recovery and getting funding into therapy. But that was a recent development.
Okay. State has no further questions, Ms. Trout.
Or do you have any questions, Ms. Stroud?
State has no further witnesses. They would like to offer any evidence, also respondents, officially offer evidence respondents statement.
So you're acting that into that, and that's what you said, true.
Yes,
Okay.
just to make the record clear.
So states exhibit 3 of the indictments.
State has no further evidence.
Proceed to
Thank you, members. Although Ms. Barrett has recently resigned, there's still no guarantee that she couldn't go work tomorrow in the hospital. In fact, that most recently, just 3 months ago, she tested positive for cocaine while she was working at a hospital. I think indicates the severe level of her dependency, let alone the fact that during RMA, she tested positive for multiple hard drugs, ecstasy, amphetamines, meth, cocaine, benzos, all at once. And then her response to that was, well, my drink was tampered with. Well, she shouldn't be drinking anyway. So I think given that, I think the only thing the board can do in this situation or should do is suspend her and give her an opportunity to actually go through with her promises to complete an RMA or at least get therapy. And as part of that suspension, maybe she can reapply or apply for the reinstatement, and condition being she has to have full continuous compliance with that RMA for a certain period of time. Thank you, members.
These proceedings according to notice are hereby concluded. This cross therefore hearings before the board. Evidence your report about this hearing is now officially concluded. Parties will no longer speak or provide additional evidence. The record is now closed. The board will continue with the transcription of its deliberations and voting in this matter. All discussions and votes will be captured in the official transcript. Board.
I agree with the state.
as well.
Okay, would you like to make a motion on
Okay, I'd like to make a motion to suspend no less than 90 days.
I would second that.
Okay, we have a motion from Ms. Major, seconded by Miller. All in favor? Aye. Opposed? Same. Motion carries 7-0-0. Thank you.
Thank you, members.
Moving on in the agenda to the summer suspension renewals and the matter of license of June. This is an administrative hearing taking place on August 20th, 2026 in Conference Center Review, Indiana Government Center Building 32, West Washington Street, Indianapolis, Indiana at 9:29 a.m. Local time is being conducted pursuant to the laws of the state of Indiana, by Indiana Code Title 4, Article 21.5% members of the Indiana State Board of Nursing, and cost document administrative trial number 2025098 UR 0138. Response name is June Marie Boone. The notice of time, place, this hearing was service provided by law on June 9th, 2026. The notice was also given to the Office of Attorney General of the state of Indiana. This hearing is determining whether respondent's summary suspension should be extended. My name is Jason King, serving as hearing officer. The board following members were seated with me: Nancy Youngst, LPN, Pearson, Justin Harlan, North, Jennifer RN, Rena Majors, LPN, and Dr. Seco. At this time, requesting any board member who believes that he or she cannot give this respondent a fair hearing in the partial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to the public each year live on the internet. It is responsibility of the parties and the council to ensure any particular health information or other confidential information necessary to the parties' case in chief be de-identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony. The witness, may we have appearance of counsel, please?
Natalie Stitt, Deputy Attorney General for the state of Indiana.
Expecting anyone to join me this morning.
I am not.
Parties to this matter have identified that the board will take official judicial notice of this file and this matter to an opening statement for us.
Yes, thank you. Just go through notice. On August 13th, I did attempt to call Ms. Boone at a telephone number that I had last reached her in November of 2025. My phone call was screened by something called Cloaked AI. I had to state my name and why I was calling, and then it sent me through to a voicemail. So I was able to leave a voicemail at that phone number. It never indicated her name, but I provided the date, time, location of today's hearing. So notice is met pursuant to Indiana Code 251910 and Indiana Code 421.5-4. So as notice has been accomplished under the law, I will move into my opening and my case in chief and closing if the board can stop me if you want at any time. This is a renewal of a summary suspension. There is a board member that was not here for the initial summary suspension, so please feel free to stop me if you have any questions or want to take time to review the evidence on the record. The initial petition for summary suspension in this case was filed on September 15th, 2025, and respondent's license was summarily suspended by the board following an evidentiary hearing held on September 18th, 2025. The summary suspension has subsequently been renewed on December 11th, 2025, February 19th, 2026, and May 21st, 2026. And today is another renewal hearing. At the hearing on September 18th, 2025, the board received and considered evidence, documentary, and testimonial that respondent represented a declared immediate danger to the public's health and safety if permitted to continue to practice as a nurse. Today, the state is going to request that the board find that respondent continues to represent such a danger. The evidence on record with the board is that respondent was providing home and community-based care to patient CK, a medically fragile 11-year-old with Down syndrome. While respondent and CK were eating lunch in the office area of CK's elementary school, CK shoved the respondent, and if you or recall the video, he is very small for his age, and the shove was essentially nothing to the respondent. And in response, she reacted by slapping him in the face with an open hand and then dragging him with her arm under his arm and around his neck off view of the security camera that was in the office. There was no audio with the camera. There was a school resource officer in the office area who heard some of what was going on and also was able to see some of what was going on. For respondent's conduct, she has pending criminal charges against her in Scott County Circuit Court. On the record of the September hearing, the board admitted State's Exhibit 6, which is the certified copy of the charging information and affidavit for probable cause. The criminal case against respondent is still pending. It is currently set for a jury trial on November 2nd, 2026. I will pause before going into closing, just if anybody has any questions, concerns. Okay, thank you so much. In that the last time that respondent was providing direct patient care, she struck a medically fragile pediatric patient in the face in reaction to a shove from the child, and that there is no known changed circumstances or remediation on respondent's part, and the criminal charges remain pending against respondent. The state offers that respondent continues to represent a clear and immediate danger to the public's health and safety if permitted to practice as a nurse. The state would acknowledge the respondent's license is expired, but the respondent's actions were egregious enough that the state represents that the red flag of a summary suspension should remain on her license during the pendency of all that's going on, and that the board would renew the summary suspension on her license for a period of 90 days and reset this matter for November 19th, 2026. Thank you.
These proceedings are going to version of this hearing is now officially concluded. Parties will no longer be able to provide additional evidence. The record is now closed. The board will continue with the transcription of its deliberations regarding this matter. All discussions and votes will be captured in the official transcript.
Make a motion to renew the summary suspension 90 days. Awesome.
A motion from George, second by Pearson. All in favor? Opposed? Same. Motion carries 7-0-0. Thank you. Moving forward in the matter of the license of James Jones. Let's verify that Ms. Morris has rejoined us. This is an administrative hearing taking place on August 20, 2026 in Congress under due to Indiana Government Center Building 32, West Washington Street, Indianapolis, Indiana, at 9:35 a.m. local time. It is being conducted pursuant to the laws of the state of Indiana, it's on Indiana Code Title 4. Party appointed 125 before 8 members of the Indiana State Board of Nursing and Cross Actions Administrative Procedure 20G602 NUR 0039. The respondent's name is James E. Jones. The notice of time and place of this hearing was served as provided by law on June 9, 2026. Notice was also given to the Office of the Attorney General of the State of Indiana. This is a hearing to determine whether respondent's summary suspension should be extended. My name is Jason King. I'm serving as hearing officer for the board. The following members of the board is seated with me: Nancy M. LPN, Dr. Pearson, Jessica Harlan, York, Kenji Morris, RN, Jennifer Miller, RN, Ray Majors, LPN, and Dr. Steve. At this time, requesting any board member who thinks that he or she cannot get this respondent fair hearing and render an impartial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to public, being streamed live on the internet. It is the responsibility of the parties and counsel to ensure any protected health information or other confidential information necessary to the parties' case in chief be identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony. Witness to any other parents of counsel, please.
Natalie Stitt, Deputy Attorney General for the state of Indiana.
Can you expect anyone to join me this morning?
I am not.
The parties in this matter hereby notify that the board will take official judicial notice of this file and recommend the matter given open statement for us.
Prior to opening, just to go through the notice requirement, as this is an emergency action. I called the respondent Jones on August 13th, 2026 at his phone number on file with the board. I left a voicemail, provided the date, time, and location with the address of today's hearing. I also referenced the email that he received from PLA Clerk on June 9, 2026 with the order, summary suspension, and notice of future proceedings, which has in writing the information of today's hearing. I did not receive a call back at any time. However, notice for this proceeding is met under Indiana Code 251910 and Indiana Code Chapter 421.54. If the please the board, I will proceed with opening and again, the substance of the case and closing unless paused. Respondent's license was initially summarily suspended for 90 days following an evidentiary emergency hearing held by the board on February 19, 2026. Following which the board determined that based upon the record, respondent represented a clear and immediate danger to the public's health and safety if permitted to practice as a nurse at that time. Today, the state is requesting the board renew that summary suspension of respondent's license for 90 days. To review the evidence on the record with the board, on November 26, 2025, respondent was pulled over by a trooper with the Indiana State Police. That was in Huntingburg, Indiana. The trooper knew that respondent had a suspended driver's license, was also familiar with the truck that was being driven by the respondent at that time. In the course of the traffic stop, the respondent informed the trooper that he was on his way to work at the waters of Huntingburg. The respondent asked if he could just leave his truck and walk to work. Based upon observations made during the stop, an additional on-scene investigation was conducted. The respondent was ultimately taken into custody and advised of his Miranda rights. The search of respondent's truck, aided by a canine, led to the discovery of drugs and drug paraphernalia, which included numerous loose pills and 2 prescription bags, one for a JB that contained trazodone, amongst other pills, and one for a patient WD, which contained gabapentin. The individuals were identified as having been residents at Harrison Healthcare Center during the time respondent had been employed there. The board also received evidence that respondent had provided care to both of those residents prior to his termination from Harrison Healthcare in August 2025 for performance and policy violations. The board further received certified copies of documents from Du Bois County Superior Court of respondent's pending criminal case based upon the traffic stop and the discovery of drugs and paraphernalia. Charges against respondent included felony unlawful possession or use of alleged drug, possession of methamphetamine, and unlawful possession of a syringe, along with 3 misdemeanor charges. At this time, the state would move the board to take official notice of a printout of the publicly accessible case summary of respondent's criminal case in Du Bois County, which has been marked for identification as State's Exhibit 8, base numbers added by present counsel.
State's Exhibit 8 was admitted into evidence.
Thank you. The state has admitted what we've marked as State's Exhibit 8. Again, this is a publicly accessible printout of what maybe, to some of the chronological case summary of what's going on with this case. On page 12 of that, this is what I wanted to reference, is there's an entry on August 10th, 2026, that the court entered a change of plea and sentencing hearing held off the record, and that a hearing would happen presumably on the record on September 1st, 2026. This is a little bit of a odd procedural note from my experience interviewing these cases, so I wanted the board to have this. It appears that he has changed his plea, which initially was not guilty, but there is no actual indication of what's happened. So right now, the state's kind of waiting for the September 1st hearing to happen. And hopefully there'll be more information for the board next time we discuss this case. In closing, the state moves the board to find that based upon the evidence on the record and no changed circumstances or remedial measures taken by respondent, that he continues to represent a clear and immediate danger to public health and safety, permitted to return to practice of nursing at this time due to his relationship with other people's prescriptions as well as illegal drugs. And upon finding, summarily suspend respondent's practical nurse license for a period of 90 days, and we set this matter for consideration for a renewal at the board's November 19th, 2026 meeting. Thank you.
These proceedings according to the notice of providing for the discount, therefore, hearing to for this evidentiary portion of this hearing is now officially concluded. Parties can no longer speak to provide additional evidence. The record is now closed. The board will continue with transcription of its deliberations and voting in this matter. All discussions and votes will be captured in the official transcript. Board.
Make a motion to renew the suspension for 90 days.
There's a motion from Ms. Barnett, second by Ms. Majors. All in favor?
Aye.
Opposed? Abstaining? Motion carries 8-0-0.
Thank you.
We'll move forward in the matter of the license of Jason Wolfenden. Understanding that he is appearing virtually. Right.
Trying to make him the presenter. Didn't need that option. We got it? Okay. Can you hear us? Unmute your microphone.
Okay, can you hear me now?
Yeah.
Can you see me?
This is an administrative hearing taking place on August 20th, 2026 at room Conference Center Room B of the Indiana Government Center Building 32 West Washington Street, Indianapolis, Indiana, at 9:44 a.m. local time. It is being conducted pursuant to the laws of the state of Indiana, found in Indiana Code Title 4, Article 21.5 for 8 members of the Indiana State Board of Nursing and Cost Act Administrative Cost number 202605 NUR 0112. The respondent's name is Judge Jason Michael Wolfenden. The notice of time and place of this hearing was served as provided by law on August 11th, 2026. The notice was also given to the Office of the Attorney General of the State of Indiana. This is a hearing to determine whether the respondent's limit of suspension should be extended. My name is Jason King, serving as hearing officer for the board. Following members of the board are seated with me: Nancy Youngst, LPN, Dr. Pearson, Jessica Ron, New York, Angie Morris, RN, Jennifer Miller, RN, Rita Majors, LPN, and Dr. Seago. This time I request that any board member who believes that he or she cannot give this respondent a fair hearing or render a partial decision to remove himself or herself from this hearing. As reminding this hearing is open to the public, being streamed live on the internet. It is the responsibility of the parties of the council to ensure any protected health information or other confidential information necessary to the parties case to be de-identified prior to disclosure, failure to properly protect patient information could result in rejection and exclusion of the testimony of the witness. May we have appearance in counsel, please?
Deputy Attorney General on behalf of the state.
Mr. Wolfenden, do you have an attorney with you?
No, I do not.
Family, you have the right to be represented by attorney in this matter. Do you understand that you have the right to be represented by an attorney in this matter?
Oh, yes, I do. I'm sorry. I didn't hear you.
Do you wish to proceed without an attorney present?
Yes, go ahead.
All right, so will all those who know themselves to be witnesses or may be witnesses in this cause, please stand and raise your right hand to be sworn. That includes you, sir. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes,
Thank you. Parties in this matter hereby notified that the board will take official judicial notice of the file and record of this matter. Do you have an opening statement for us?
Yes. The state has received mitigating information that has led the state to conclude that Mr. Wolfenden does not continue to represent an immediate danger, and the state would request that the summary suspension be allowed to lapse at this time.
Thank you. Mr. Wolfenden, do you have an opening statement?
no, I do not.
Thank you. You may proceed.
The state rests.
Okay. Sir, do you have anything else that you would like to add on your behalf?
No, not, no.
Do you have a closing statement for us?
The state would just ask that you allow the summary suspension to lapse.
Mr. Wolfenden, do you have a closing statement for us?
I'm sorry. I didn't hear what you said.
Do you have a closing statement for us?
No, no, I do not.
These procedures according to the notice, we hereby conclude this cause is therefore adjourned until further order. The evidentiary portion of this hearing is now officially concluded. Parties can no longer speak or provide additional evidence. The record is now closed. The board will continue with transcription of its deliberations and voting in this matter. All discussions and votes will be captured and the official transcript. Board?
The question before. Assuming this will still be set for a hearing. Okay, sorry, go ahead. Make a motion to allow the next discussion, that's.
We have a motion on the table. Do we have a second?
I'll second it.
The Seago Miller, all in favor? Aye. Opposed? Abstained? Motion carries 800. Mr. Wolfenden, did you understand what just happened? That was a yes.
You're muted.
Okay. Just making sure. Thank you.
You're muted, we can't hear you.
All right, we are going to take a 5-minute break, and then when we come back, we can jump ahead in the agenda to default hearings because we're running a little bit early. Default hearings, we're going to take a 5-minute break. All right, we're going to move forward on default hearings. Dr. Spigo is still out in the hall, but we do have quorum, so we're going to continue. In the matter of the license of Sandra Cabinet. We have Sandra Cabinet. Last call for Sandra Cabinet. This is an administrative hearing taking place on August 2026, the Conference Center, Room B of the Indiana Government Center, Oakland Street, 2 West Washington Street, Indianapolis, Indiana, at 10 o'clock local time. It is being conducted pursuant to the laws of the state of Indiana, as found in Indiana Code Title 4, Article 21.5, before 7 members of the Indiana State Board of Nursing and the cost practice administrative cost number 2025112, NUR 0178, respondent's name is Sandra K. Avenett. A notice of proposed default order was issued in this matter and filed on July 20th, 2026. The notice of proposed default order was served on the parties required by law on July 20th, 2026. Notice was also given to the Office of the Indiana Attorney General. Response to the notice of proposed default order was not received from the respondent. The purpose of this hearing is to conduct any further proceedings necessary in order to conclude this matter. My name is Jason King. I'm serving as hearing officer for the board. Following members of the board are seated with me: Nancy Guns, and Dr. Pearson, Jessica York, and Morris are in. Jennifer Miller are in. Being majors of LPN. At this time, I request that any board member who believes that he or she cannot respond to fair hearing or render a partial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to public, being streamed live on the internet, and it is responsibility of the parties to constitute or any protected health information or other confidential information necessary to the parties' cases to be identified prior to disclosure. Failure to properly protect patient information could result in objection, exclusion, of testimony of the witness. May we have appearance of counsel, please?
Whitney Cooper on behalf of the state.
Do you expect anyone to join me this morning?
I don't think so.
Parties this matter hereby notified that the board will take official judicial notice of its filed record in this matter. Can you make any statement for us?
Sure. So we'll start with notice here. You already kind of went through this, but last 2 months, June 18th of 26, we were scheduled to have a final hearing with Ms. Avenett. I was here, she was not, she was given proper notice, but she didn't appear. You issued a notice of proposed default. You've noted today that there's been no response received, and therefore I would request that you hold her in default.
Board.
Motion to hold her in default. Is there having that? I'll second.
Majors Miller, all in favor?
Aye.
Opposed, abstaining, motion carries 7-0. You may proceed.
Thank you. So we've charged Ms. Avenett with 6 counts. Those are using unsafe judgment, technical skills, or inappropriate interpersonal behaviors in providing nursing care while she was working with them. Second would be falsifying, omitting, or destroying documentation on the official patient client record with them, diversion of alleged drugs out with them. Count 4 is a conviction of a crime that has a direct bearing on her ability to practice confidently, that being an OBWI with an ACE of 0.154 or more. Count 5 is another conviction. This one is for a crime that's harmful to the public, that being her conviction for failure to make, keep, or furnish records. And then last is a count of renewal fraud from 2021. I've already taken official notice of your file, so you know that in 2025, Ms. Avenett did not request to renew the license, so it's been expired since November 1st of 2025. I'll give you evidence, and then we can kind of decide how we're gonna resolve this case. So to that end, I would move for the introduction of state's exhibits 1 through 8. I'll tell you what they are. Exhibit 1, these are criminal records regarding respondent in Johnson County. Exhibit 2, this is the license renewal application submitted by Ms. Avenett in 2021. Exhibit 3 are certified criminal records regarding respondent for a criminal case in Morgan County, Indiana. Exhibit 4, these are Iowa employment documents for respondent. 5 is the consumer complaint that we got from Witham regarding respondent. Exhibit 6, this is the investigative file
regarding respondents' nursing practices at Whitlam. Exhibit 7 is the DEA Form 106 that was submitted by Whitlam. And then Exhibit 8, these are certified criminal records regarding respondent for yet another criminal. So I would move to admit states exhibits 1 through 8.
These exhibits 1 through 8 amended as.
Thank you. So we'll go through these. Exhibit 1, these are criminal records from Johnson County. What you can see here is that in 2019, Ms. Avenett drove her car onto one of her neighbor's properties and sheared off a tree in the process. Presumably not super mature tree, but broke the tree and then left the scene of the accident. And the neighbor was able to figure out through security cameras who it was. And in November of 2019, she was charged in Johnson Superior Court with leaving the scene of an accident as a Class B misdemeanor. You'll find in the documents that she took a diversion agreement in January of 2020, which meant that once she completed it, the case was dismissed. So then we have Exhibit 2, which is the license renewal application submitted by her in 2021. Now, what she should have done was said, yeah, I had a criminal case filed against me and I entered into a pretrial diversion agreement. You asked about that on renewal applications. She did not disclose that. So based on what we've just talked, she should have said yes when she said no. Exhibit 3, these were certified records from Morgan County. So we've gone from Johnson County, now we're in Morgan, circling Indy. In this case, she was driving erratically and hit the concrete barrier on I-69. When the cops arrived, she said she was in a rush to get to work. And that's why she was driving erratically and lost control of her car. They suspected otherwise. They breathalyzed her. Her blood alcohol content was 0.233. So she was charged in Morgan County with OBWI, an ACE of 0.15 or more, and an OBWI endangering the person. And on page 5 of this exhibit, we see that she took a plea agreement where she pled guilty to OBWI with a BAC of 0.15 or more and was given a year of probation. Again, I would remind you, she said she was trying to get to work when she was driving drunk. Exhibit 4, these are IA employment documents. First page, we can see she started at IA, it's a staffing agency, in September of 22. Page 3 is the contract that she signed where IA placed her to work at Witham Memorial from January 9th to April 8th of 2023. And on the very last page of that exhibit, which is page 73, we'll get into this more in the next 2 exhibits, but this shows at the top of the box, it shows, quote, clinical manager met with facility today to answer any questions they had regarding reporting. All questions answered, and they will be reporting Sandra to the Board of Nursing. Please reach out with any additional questions. And again, documents from the staffing agency, and they're saying Witham's going to report this. And in Exhibit 5, Witham does report it to the state. April 2023, Witham files consumer complaint against Ms. Avenett. And on pages 3 and 4, we can see there were Pixis interactions involving respondent. They ran an audit, and it shows a whole lot of documentation errors. Just looking at the first couple bullet points is concerning. Lots of times where she's not scanning the administration of meds, that she's pulling, among other things. Exhibit 6, investigative documents from Witham, pages 1 and 2 explain that in addition to the issues that we talked about on that consumer complaint with all the lack of scanning, she was also noted to be rude to patients and coworkers. Her nursing judgment was at issue. She was trying to put magnesium in a nutrition feed and also was going to do cardizem before she did an EKG. Y'all are nurses, you probably know that's a very bad idea. So those are some of the other issues. The next 2 pages, so 3 and 4, that's a summary of the statement by her boss at Witham. And this explains that when the unit manager developed the foregoing concerns, she asked the pharmacy to run an audit. That's how we get that 2-page printout that's on the consumer complaint saying, boy, she didn't scan or administer a whole lot of meds. DEA 106 is Exhibit 7. This shows us on page 2 and at the top of 3 that they think they lost 10 oxycodone tablets, 5 milligram, 2 hydro 10 mil, 2 oxy 10 mil, 1 oxy 8-pap 5 mil, 2 tramadol, all attributable to Ms. Avenette. And then it says in the middle of page 3, agency RN, that's Ms. Avenette, removed controlled substances from the Pyxis, subject to valid order. No administration documented in EMR occurred for various patients during her tenure here. Remember, her tenure here only started in January of 23. So by April, we have lots of issues. And then finally, Exhibit 8, these are certified criminal documents regarding what happened at Witham, the controlled substances that she diverted while working at Witham. And on page 10 of Exhibit 8, you can see judgment of conviction was entered after she entered a guilty plea to failure to make, keep, or furnish records as a level 6 felony. So, we charged Ms. Avenette with 6 counts. I think those are all pretty easily proven here. So we've got criminal contact twice before she stole drugs from work. One definitely involving alcohol. That's the OBWI where she hit the concrete barrier. And I have my thoughts about the other one when she ran over her neighbor's tree. She was at the scene of the accident. So we're never going to know whether that involved alcohol, but I have my thoughts. She didn't report the diversion agreement that she entered into after being criminally charged for leaving the scene of that accident in 2019. When she renewed in 21, got a contract to provide nursing at Witham, and within just over a month, things started to go very badly. They determined she diverted drugs, failed to document appropriately, rude to patients, violated policy regarding TPN and cardizem, and was terminated from her contract. Then she was charged in 2023 by my office related to those actions at Witham, convicted in May of 2025. In 2024, after my office charged her for the Witham stuff, but before she resolved that case, she actually resolved the OBWI from Morgan County, where she hit the concrete barrier. So that gets us that extra conviction. So I'm confident. I've proven all the allegations. What do we do about it? Easy stuff first. $1,000 fine for the renewal fraud, I think is your standard. The $5 health records fee and the cost of proceedings. Now, what do we do about the license? She let the license expire, so perhaps that's an indication of her intention regarding this, right? But if you think maybe she does want a chance to try again, then you could go with an indefinite suspension. And I would ask if you do that you order her to be in and complying with an ISNAP RMA in order to be eligible for reinstatement, among anything else you would think appropriate. But I think the evidence here would support a revocation if that's the direction that you wanted to go. That's my evidence. Thank you.
These proceedings according to the notice of provide terms with further order in the board and the interior portion of this hearing is now officially concluded. Parties can no longer speak or provide additional evidence. The record is now closed. The board will continue with the transcription of this deliberation and voting in this matter. All discussions and votes will be captured in the transcript.
Agree with the state's made this case.
On all 6 accounts.
Anybody disagree? Others would like to proceed?
I agree with the renewal fraud, the cost of the proceedings and the health fee. And I think we could have a conversation about the license.
I say that because I'm okay with suspending him, but he's also not here, pension expired, so I think go further.
I agree with you. I mean, to suspend the license when she's not engaged in the process. But, does anyone propose revocation at this point? No. Well, yeah.
You want to finish them? Because you got $1,000 for the fraud and then the aggravating factor is attempted to sue. Cost of proceedings $5.
Right, for a second.
That's Miller and Morris, all in favor?
Aye.
Opposed, abstained, motion carries 7-0-0.
Thank you.
Moving forward in the matter of license of Misty Fakes. Misty Fakes. Last call for Misty Fakes. This is an administrative hearing taking place on August 20th, 2026, in the room conference room via the Indiana Government Center, Building 32, West Washington Street, Indianapolis, Indiana, at 10:17 a.m. local time. It is being conducted pursuant to laws of the state of Indiana, as found in Indiana Code Title 4, Article 21.5, for 8 members of the Indiana State Board of Nursing. Any cross documents administrative code number 2022511 AUR 0160. The respondent's name is Misty D. Fakes. A notice of proposed fall order was issued as a matter of filed on July 20th, 2026. The notice of proposed fall order was served on the price required by law on July 20th, 26. Notice was also given to the Office of the Attorney General. A response to the notice of proposed fall order was received from the respondent. The purpose of this hearing is to conduct any further proceedings necessary in order to conclude this matter. My name is Jason King. I'm serving as hearing officer for the board. Following members are seated with me: Nancy Young, LPN, Dr. Pearson, Jessica Harlan, Norton, Andy Morris, RN, Jennifer Miller, RN, and Rita Majors, LPN, and Dr. Seco. At this time, I request any board member who believes that he or she cannot get this respondent fair hearing and a partial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to the public, being streamed live on the internet. It is responsibility of the parties and council to ensure any potential health information or other confidential information necessary to the parties' piece of TPT identified prior to disclosure. Failure to properly protect patient information could result in rejection and exclusion of testimony related to the parents and council, please.
Whitney Cooper on behalf of the state of Indiana.
Are you expecting anyone else to join you this morning?
I'm not, but I will advise the board that yesterday I was contacted by an attorney in Evansville. His name is Verdelsky Miller. He indicated that he has been retained by Ms. Fakes, and that he would, and he did. Yesterday, he entered an appearance on behalf of Ms. Fakes. Beyond that, Ms. Fakes did timely respond to the notice of proposed default. I would have absolutely no objection to setting aside the notice of proposed default and giving myself and Mr. Miller an opportunity to try to resolve this case. He's indicated to me his client is interested in resolving this case actively with her participation. So I would ask that we set it aside and reset this for dates in the future.
Board,
Motion to set aside. Second. Case with Misty Fakes.
we have a motion by Ms. Majors, second by Ms. Harlan York. All in favor?
Aye.
Opposed? Abstained? Motion carries 8-0-0.
Thank you.
These proceedings are according to notice. Thank you for the board. Moving forward to the matter of the license of Daniel Livingston. Daniel Livingston. Last call for Daniel Livingston. This is an administrative hearing taking place on August 20th, 2026, in Congress Senate review the Indiana Government Senate Bill 32 West Washington Street, Indianapolis, Indiana, at 10:20 a.m. local time is being conducted pursuant to the laws of the state of Indiana, by Indiana Code Title 4, Article 21.5, for 8 members of the Indiana State Board of Nursing, and it files an act administrative file number 2022 NB0020. The respondent being Camille C. Livingston. Notice of proposed default order was issued in this matter following July 20th, 2026, and this proposed default order was served on the part of this required by law on July 20th, 2026. Notice was also given to the Office of the Attorney General in response to the notice of proposed default order was not received from the respondent. The purpose of this hearing is to conduct any further proceedings necessary in order to conclude this matter. My name is Jason King. I'm serving as senior officer of the board. The following members of the board are seated with me. NCS, LPN, Dr. Pearson, Jessica Harlan, York, Angie Morris, RN, Jennifer Miller, RN, Major LPN, and Dr. Cito. At this time, I request any board member who believes that he or she can act in a respond to paragraph or render a partial decision to move himself or herself in this hearing. As a reminder, this hearing is open to the public, being streamed live on the internet. It is the responsibility of the parties and council to ensure any protected health information or other confidential information necessary to the parties needs to be identified prior to disclosure. Failure to properly protect patient information could result in rejection and exclusion of testimony of the witness. May we have the appearance of counsel, please?
Deputy Attorney General Auditor on behalf of the state.
And are you expecting any witnesses today?
Yes. The state is going to call Brianna Foster and a representative of IKLA just for confirmation that respondent is not on the live stream.
Will all those who know themselves to be witnesses or may be witnesses in this cause, please stand and raise your right hand and be sworn. You and each of you solemnly swear or affirm under penalty of perjury that the testimony about given this cause may be true, the whole truth, and nothing but the truth. Parties in this matter hereby notified that the board will take official judicial notice of the following record in this matter. Do you have an opening statement for us?
Before I give my substantive opening, I would just like to give a notice opening and then call Ms. Adams just to confirm the live stream attendance issue. So on May 6th, the board issued an order to cause notice to respondent and serve the hearing notice by email for a hearing on June 18th. The hearing notice did contain a paragraph of failure to appear, which resulted in respondent being held in default. However, on June 18th, the respondent failed to appear. As such, on July 20th, a notice of proposed default and notice of future default proceedings was filed and it informed respondent that he had an opportunity to file a written motion within 7 days. And if a default order is entered against respondent, that the board will hold future proceedings without his participation. That notice also included a paragraph regarding today's hearing of the time, date, and location of the state. The state has received no communication from respondent or written motion in response to the notice of proposed default. At this time, we will call Connie Adams just for some brief questions. Can you spell your name for the record, Ms. Adams?
It is Connie Adams, CLNNIE,
And where are you employed?
with IPLA.
And what is your, what are your duties as they pertain to the board meetings?
I help to monitor the live stream as well as take minutes and
Do you have access to today's live stream?
I do.
Can you review the participants list and confirm that someone by the name of Daniel Livingston is not on the live stream?
I do not have that name listed.
Do you have any attendees that are listed by only phone number?
I do not.
At this time, the state has no further questions from Ms. Adams, and we move to hold the respondent default.
Or
Motion to hold the respondent default. Okay.
you have a motion by Ms. Major, seconded by Dr. Seaver, all in favor? Aye. Opposed, abstained, motion carries with 0-0. You may proceed.
My substantive opening respondent has failed to abide by the board's order specifically regarding IPRP compliance with the rule of your testimony today. The respondent has been discharged from that program. Additionally, you will see an affidavit from the IPLA litigation coordinator outlining other terms of his board that he is not complying with.
It's important to remember that for order to show cause proceedings, it is his burden today to demonstrate why further sanctions should not be imposed, and he has failed to appear after due notice. As is the board precedent, the state intends to request a minimum of suspension with a period of IPRP compliance because probation has clearly not worked for this respondent. At this time, the state calls for you to foster. Can you spell the name of the report, please?
PRINAMOSTER.
Where are you employed?
Indiana Professional Recovery Program.
And are you familiar with respondent Daniel Livingston?
Yes,
And how are you familiar with him?
I was his clinical case manager.
And when were you his clinical case manager?
Between July, oh, sorry, not July, between January of 2026 and March of 2026.
Do you have access to his IPRP file as you sit here today?
Yes,
And did you write an IPRP memo for respondents' file?
yes.
Let the record reflect that I'm showing on my computer, the witness, what has been marked as proposed exhibit B. What is this document?
That is in order to show cause.
And who wrote this document?
I do.
Is this copy a very accurate copy of the version that is part of IPRP's file?
Yes,
At this time, the state moves to admit exhibit B.
State's exhibit B admitted into evidence.
Ms. Foster, can you walk through the pertinent noncompliance for this participant?
yes, so it looks like as far as compliance, yes, six missed check-ins. We had one no-show VS, and after that no-show VS, we were unable to get in contact with him.
Did he have any missing reports or missing meeting logs?
No,
What did IPRP do with respondents' participation?
we, unsuccessfully discharged.
And was he notified of this?
Yes, he was.
And have you had any contact with Mr. Livingston since his discharge?
No,
Is there anything else you would like the board to know about Mr. Livingston's participation in IPRP? I have no further questions. Can we let the board make questions?
Or do you have any questions for this witness? May I proceed?
At this time, the state moves to admit exhibit C, which is the IPLA affidavit.
State's exhibit C admitted into evidence.
I think on your end, the exhibits may be 2 and 3. I apologize for that. Just for clarity of the record, exhibit 2 is the IPLA affidavit and exhibit 3 is the IPRP memo.
I'm sorry, who is that?
I said I can only see exhibit 3. I haven't been able to find exhibit 2.
This way. Mine just showed up. I think there's a little bit of a lag, yeah, so it should have been like this. If you're going to the next, yeah.
And at this time, the accused has no further evidence and would like to move to person.
May I proceed?
As you've heard today, and as you have reviewed in evidence, this respondent has not complied with his court order. It was his burden today to show cause why further sanctions should not be imposed. as that was, what was noticed and what was contemplated in his board letter. The state recommends that you impose at minimum a 1-year suspension with a requirement that he obtain 1 year of complete and continuous compliance with his IPRP RMA, and that he also be able to complete some continuing education, which I will leave to the board to determine what categories would be appropriate. But at minimum, I think 6 to 12 would be appropriate. That's all I have.
These proceedings according to the notice and hereby adjourned until further order of the board, and interior portion of this hearing is now officially concluded. Parties can no longer speak or provide any additional evidence. The record is now closed. The transcription will continue deliberations and voting in this matter. All discussion and votes to be captured in the official transcript. Board.
I think the state perfectly so on counts. Open for discussion on the licensure, I would add, I believe, I'd rather have the proceeding, possible proceedings.
So is that your motion for the 1 year suspension and then?
I said I would be open to conversation.
Board, any thoughts around the length of time on the suspension, or do you believe that? Does anybody disagree with the suspension? Let's put it that way.
I feel like we can go even further. He's not very interested in, he's not very interested in, participating, and I would might even go further than suspension.
Her name is only 2 years. Yeah. I'm sorry. No.
Their quarterly reports, we haven't paid him time, and he's not submitted any signed board orders, no education, and he's not participating in a lot, so that's why we would be going in front of the reopen his license.
I can go either way.
Place to revocation.
I don't know. Sure, but this is essentially pretty new. Takes a little bit sometimes, but I don't know that I'm all the way to revocation. I've done the 1 year suspension, and then if they're not compliant, we tend to have that resident, it could be moved directly from probation to revocation. I personally think that's.
March.
This is his first RMA.
Just understanding that people into that a lot of times the lapses are, it takes 7 times, but, evidence shows that sometimes it takes 7 lapses before people can finally have sobriety. And so, it's just something to consider. I personally think that instead of one, you ought to do a suspension, and then if he's not compliant, to be.
I'll read that. Is the 1 year suspension.
I'm sorry, who was just speaking just now?
I'm sorry, me. You want to go like that?
My original, motion for 1 year suspension. Engage with ISNAP and his RMA and have complete and full compliance with that RMA for no less than 12 months. Cost of the proceedings, $5
They mentioned continuing education for 6 to 12 credit hours. So could we add something like that as well?
What would you recommend it to be? I wasn't,
Impaired nursing substance abuse. All 12.
Six, and then, volunteer coding maybe? Number six. Volunteer coding.
So are you my second?
Major second.
So we have a motion for 1 year suspension, 12, and must be compliant with ISNAP for 12 months, continuing 12 months. $5 health record being cost of the proceedings, and then the 12 total CBUs. Okay, so we have a motion from Miller, second from Ms. Majors, all in favor? Opposed, abstained, motion carries 8-0-0.
Could you repeat the breakdown of the CEUs for me? Was it 6 in one and 6 in the other?
6 in impaired nursing and 6 in self-care and cooking.
What's the first subject? 6 in impaired nursing. Impaired nursing. Thank you.
I don't believe we can move forward on anything. All right, so at this time, we are in recess until 11 o'clock. All right, board, a couple updates. Number 3 under the final hearing, Adriana Keller has been continued. And then number 7, Kimberly Pilkington, also continued. So that moves us in the matter of the license of Lynette Margulis.
That's my mic. You just watch my mic. You just start to rub on. I'm sorry. I don't know if I said your name wrong as well. Sorry.
I didn't even hear you.
Okay.
So you want this where?
You can leave it right there. Just letting you know it's a hot night. So.
Okay. Oh,
Thank you.
that's a good enough, good to know.
And did I pronounce your name correctly?
Leonette Markoulis.
Margulis.
Thank you.
And Lynette. This is an administrative hearing taking place on August 2026 in Congress over Indiana Government Center Building 302 West Washington Street, Indianapolis, Indiana at 11:04 a.m. local time. It is being conducted pursuant to the laws of the state of Indiana, Southern Indiana Code Title 4, Article 21.5, and for 7 members of the Indiana State Board of Nursing and Cost Factors Administrative Cost Number 2025090 UR0132. The respondent's name is Lynette Christina Markoulis. The notice of time and place of this hearing was served to the parties required by law on March 24th, 2026. This is the final hearing of the state's complaint, which was filed September 8th, 2025. My name is Jason Key. I'm serving as hearing officer for the board. The following members of the board are seated with me: Nancy Youngstown, and Dr. Pearson, Jessica Harlan York, Angie Morris, Rena Majors, LPN, and Dr. Siegel. At this time, I request that any board member who feels that he or she can act as respond to fair hearing or in the partial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to public. These should rely on the internet. It is the responsibility of the parties and council to ensure any protected health information or other conditional information necessary to the parties' case and chief be identified prior to disclosure. Failure to properly protect patient information could result in rejection and exclusion of testimony of the witness. May we have the appearance of counsel, please?
Amanda Elizondo Cassidy for the state.
Laura Yazway, last name Iosue, for Ms. Markoulis. I have a certified legal intern appearing with me today too, Audrey Odell.
For all those who know themselves to be witnesses or may be witnesses in this cause, please stand and raise your right hand and be sworn. You and each of you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth.
Yes.
And be seated. The parties in this matter hereby notified that the board will take official judicial notice of this filing record in this matter. You have no pending statement, of course.
Before that, Ms. Yazway and I had spoken once we exchanged our final exhibits. And I would like to make a motion that we stipulate to our exhibits.
And that would be your exhibit A through, no, 1 through
1 through 7.
6. 7?
There's 7.
What's the 7?
It is.
Oh, hold on, I got it.
Oh.
I think I know that.
The last.
Yeah. Right. Yeah. And then also I have one exhibit, Exhibit A, which I want to be sure was uploaded to the SharePoint. There was an email that came through that, when I sent the exhibits, an email came after that saying, oh, I don't want to submit it until I know this is all you're going to do, but has it been submitted?
Your exhibit A is.
That, thank you. I made that way more complicated. Thank you, Amy. Yes. Okay,
Okay, great.
so we would have to,
We would ask to stipulate the exhibit
and admit them.
and admit them.
So state's exhibits 1 through 7 admitted to evidence and respondents in exhibit A admitted to evidence.
And did you say 1 through 7? Okay, sorry.
All right, thank you. On February 16th, 2024,
Ms. Markoulis was working as a nurse at the Waters of Columbia City. During her medication pass, she accidentally administered an MS Contin 30 milligram tablet to a patient, SJ, who was not prescribed any opioid medications. Not only was SJ not prescribed any opioid medications, she was a patient with numerous respiratory conditions. She had COPD, chronic respiratory failure with hypoxia. She recently had COVID and she was also on supplemental oxygen. Later that day, SJ passed away. Respondent was suspended during the course of the facility's investigation, and she was eventually given a written warning for her administration of the MS fund. IDOH surveyed the facility in the next week and issued 2 tags related to their quality of care and their failure to keep residents free from significant medication errors. Despite her suspension and written warning, when Ms. Markoulis renewed her nursing license, she failed to disclose that employment testimony. At the end of the hearing, I'm going to ask you to find that she exercised unsafe judgment in her administering that medication, that she diverted medication from a patient who had an order for that medication to a patient who did not, and that she committed renewal fraud when she failed to disclose her discipline afterwards.
My client fully admits that there was, is this coming through because my light's not on?
Sure.
I have pushed it. It's not turning green.
It's gonna turn red.
Yeah. Yeah, it's on. My client fully admits that she made a mistake. And apparently, the state also admits that this was an accident. It was a mistake. Every mistake is not discipline. Sometimes it is, but sometimes it's not. Particularly when you do everything you're supposed to do afterwards to remedy that mistake. There's not a single person in here who could say they've never made a mistake in their work. We all have. The issue is that this facility created an environment where mistakes were ripe to happen. They had my client trying to do too many things at one time, while she was also trying to administer critical medication. The fault, while she admits she made this mistake, the subsequent actions are not with her. The facility is at fault. The client admits there was a mistake, but the outcome of this matter is not on my client. And the situation leading up to it is not on my client. She did everything she could to do this right. You will also find out in the evidence today that my client is the only person from the facility who has been charged with this matter. Even though after she left shift change, you will see, no one followed up to see how that patient was doing. And the nurse practitioner took no action. And the DON took no action. Yet my client is the only person who charges have been brought against. In addition, you will also see that in the survey materials, the survey found the facility at fault for not ensuring that there was proper assessments after for not ensuring that there were proper assessments after changing condition. And that the facility pointed to the DON who have done that. So for those reasons, we will ask you to find my client did not violate the first 2 allegations of unsafe judgment and technical skills. And diversion, that carries with it an idea of intent, which this absolutely was not a diversion. This was a mistake. With regard to renewal fraud, the evidence will show you that that was a misunderstanding of what the question was asking versus how this board interprets that rule or that question. So for those reasons, we will ask you to find that my client did not commit misconduct. If you do find that she committed misconduct, we would ask for a public reprimand or no discipline.
State may proceed.
The state called Jennifer Smith. State can spell your name.
Jennifer Smith, JENNIFER
And how are you employed?
I'm employed with the Indiana Attorney General's office,
And how long have you been with the OAG?
20 years.
And can you tell us briefly, what are your duties as an investigator?
I'm an abuse and neglect investigator, so I look into complaints that are alleging abuse and neglect of residents at long-term care facilities.
And in the course of your investigation, like what kind of tasks do you do?
I usually do facility visits where I go to the facility, visit there, give them subpoenas for information regarding the complaints. I reach out to sometimes the family members or witnesses and do interviews.
And about how many investigations do you think you've done over the course of your career?
Since I've been at the Medicaid Control Fraud Unit, probably in between 200 and 300.
Are you familiar with Lena Mark?
Yeah.
How are you familiar with her?
She was the suspect in a complaint I received to investigate from the waters of Columbia City
And how did that case come to you?
through the State Department of Health.
What was the initial complaint about?
The initial complaint was
You can object as to hearsay and relevance.
Hearsay is admissible. I'm just trying to get where we're going, and she surely has personal knowledge to know what the complaint was about because she was investigating it.
I didn't argue to speculation, I argued to relevance, so.
The relevance is that this is the whole crux of why we are here today.
Overall, please continue.
And can you please use your mic? Oh, sorry.
Is it on? Mine wasn't on, right?
Is it on? Can you hear it? Okay. What was the initial complaint about?
the initial complaint was regarding a resident had received somebody else's morphine. And the respondent, was going to continue to do checks on the resident.
What ultimately, well, is it okay to call this patient as Jen?
Yes.
What ultimately happened to patient as Jen?
She ended
Again,
up,
I don't want to be obstructionist, but as this body knows, if hearsay is not, well, hearsay is admissible, it cannot make the sole basis of a finding. Unless, it cannot form the sole basis of a finding if that, hearsay has been objected to. And so, I am concerned about not making my objections timely. I don't want to be interrupting. I'm a little concerned about just having a standing objection as well. So I just want to warn you all that I'm going to be objecting as to hearsay. So objection hearsay.
What ultimately happened to patient as Jen?
the patient, ended up passing away later in the day that the medication error was made.
What steps did you take in your investigation?
My initial step was to do a facility visit in which I gave the facility a subpoena for different documents related to the resident, the facility investigation, the respondent. I also contacted the coroner's office for his report, ISDH for their survey, and the local police department for their investigation.
I am going to hand you what's been marked as State's Exhibit 1. And can you tell me what that is?
The State Department of Health survey.
So starting on page 1, what was the facility tagged with during the survey?
They were tagged with an F684 and F760.
And what are those What do those tags mean?
F684 is the, quality of care tag, and then F760 is residents are free of significant med errors.
Now, the survey refers to resident Q. Is that the same patient as patient SJ?
Yes.
We may call her resident Q, we may call her patient SJ, that's the same person that we were talking about. What were SJ's?
I'm sorry, I'm so sorry. Can we pause for just a moment? Hitting that mic really hard. I'm so sorry. I just need to move it. I'm so sorry. Please excuse me.
Am I the one getting this mic?
You're not getting disciplined. I just need to move it. You're hitting the mic and it's me. I'm so sorry. It's just it's a very,
I'm not getting disciplined.
yeah, I thought you said, are you getting yelled at or disciplined?
No, I said, am I getting this mic?
Yes.
I was like, okay, this is not the room to be
You're
making
hitting
those
the mic
choices.
pretty hard. It's okay, it's okay, it's okay. My apologies. Please continue. I apologize.
Looking at page 3 of the survey, what were patient SJ's diagnoses?
And I would, again, I'm not trying to be pain, but these documents are in evidence. They've already been admitted. To have somebody just sit there and read through them, I don't think is worth this body's time. And I think it's cumulative to have somebody just read what's in front of you. So I would object as to cumulative.
We will listen.
Her diagnoses included chronic obstructive pulmonary disease, which is COPD, dependence on supplemental oxygen, chronic respiratory failure, diabetes, and chronic pain syndrome.
And why was she at Waters?
She was at the Waters for therapy after a recent hospitalization from sepsis due to a UTI.
Prior to this incident, was she on any opioids?
No.
And I would object as to hearsay.
So we will.
So after she was administered the MS content, what happened next?
No, I would object. That's not in evidence.
I can ask some preparatory questions. You mentioned that the survey referred to a medication error. What was the medication error that the survey discusses?
And again, hearsay, objection.
The medication error involved a 30 milligram pill of MS cotton.
And what happened with the 30 milligrams of methamphetamine?
It was given to the wrong resident,
And which resident was it given to?
resident SJ.
After resident SJ was administered the MS content, what happened?
The respondent texted,
Objection. Hearsay, speculation. Or may I ask a preliminary question?
Are you asking if you can ask the preliminary questions or?
Yes, to lay the foundation for my objection, please.
Your question.
You were not there on February 16th at the Waters, were you?
no,
You have no firsthand knowledge of any of this, correct?
just decide what's in the documentation.
Okay, so anything that you are testifying to is something that you read, right?
Correct,
That somebody else wrote down.
correct.
Okay. So I would object as to speculation and or hearsay.
I would argue that hearsay, again, is admissible. These documents are already in evidence and have been stipulated to. So we can discuss.
While we stipulated that the documents have been admitted, the statements contained therein are still hearsay. So we have no objection to the documents being admitted as to they were authentic. but the statements contained therein, and particularly now the double or triple hearsay from a witness who was not there, just reading off the documents that are already in the record is hearsay. So I would object.
So we have something Wayne.
With the objection, you pretty much objected, answered this several times.
And please know I'm making my record.
Overruled, please continue.
I'm not sure what I just asked.
I think you said what happened next step. Well, you can.
What happened after that question?
The respondent texted the nurse practitioner, and then also the family member of the resident was called, and the respondent stated that she would keep an eye on the resident.
I'm gonna hand you what's been marked as exhibit 3. Can you tell me what this is?
This is records from the facility that include the patient's medical records
And how did we obtain these records?
through a subpoena that I served at the facility.
I'm gonna have you turn to page 104. And can you tell me what this is?
Change in condition evaluation.
And what is the change in condition that is being described?
It was considered another changing condition, and it was listed as medication error.
I'm gonna have you turn to page 106. Are any new orders referenced?
No. Actually, it says to monitor and report any changes in mental status or vital signs.
I'm gonna have you turn to page 79.
What'd you say?
79. Can you tell me what this is?
This appears to be a list of vital signs records from the resident.
You mentioned that you had done 200 to 300 investigations over the course of your career. Does that involve looking at medical records?
Yeah.
Would you say that you look at different formats of medical records often?
Yes.
So from your experience, on the left side of the page, it says date, and on the right side of the page, it says recorded date. What do those two, in your experience, what does the date stand for?
The date that the vital signs were taken.
And what does recorded date generally mean?
The date that they were entered into the computer system.
How many blood pressure readings were recorded for patient SJ after she was administered the MS content?
2.
And how many of those were entered prior to SJ?
1.
Okay, I'm gonna have you turn to the next page, page 80. How many, first I'm gonna ask you what this is.
It appears to be her oxygen saturation level.
And this page has, again, a date and a recorded date for each of those readings.
Yes.
How many oxygen readings were recorded for patient SJ after she was administered the MS content?
2.
And how many of those were recorded prior to SJ's death?
1.
Okay, I'm gonna have you turn to page 231. For these, we're gonna be looking at progress notes, so we're going to be reading from the bottom of the page up. So at the bottom of the page, we can see the note about the change of condition. And there are 2 dates on that note. There's a created date and an effective date. Based on your experience reviewing medical records, what does a created date mean?
The created date would mean the date that the information was entered into the computer,
And what is an effective date?
the date that the information was taken.
And when was this note created? The very bottom of the page.
It was created on February 16th, 2024,
At what time?
11/13.
And what was the effective date?
February 16th, 2024 at 8.
I'm gonna have you scroll up to the next note. What does this note say?
The note states, follow-up in regards to medication error. Resident is alert and oriented, able to make needs known to staff without difficulty. No signs or symptoms of adverse effects noted from medication MS-COM. Resident continues on O2 at 2 in nasal cannula. Writer reminds resident to keep nasal cannula in nose as she frequently removes it. Writer noted resident continues to spit up phlegm as previously noted. BRSO are clear and diminished. This is baseline for resident. Vital signs and neuros are within normal limits. We'll continue to monitor.
And when was that note created?
February 17th, 2024 at 14:03.
And what time was it effective for?
February 16th, 2024 at 9:30.
And have you scroll up to the next note? Okay, and what does, we are now up a page, I'm sorry, 230, yes. What does this note say?
Follow-up for med error. Resident is sitting up in her chair in her room, alert and oriented. Vital signs and neuros are within normal limits. No signs or symptoms of adverse effects from medications at this time.
And what is the effective date?
February 16th, 2024, 11.
And what is the created date?
February 17th, 2024 at 14:05.
So then we're gonna keep scrolling up the page. Next one up the page, what does that say?
The note states, continue follow-up on medication error. Resident is alert and oriented, able to make needs known to staff, up in wheelchair in room, eating lunch at bedside. Writer checked vitals and neuros at this time. They are within normal limits. Writer asked resident how she was feeling. Resident stated she was feeling okay and the buzz was worn off. Writer again apologized and expressed concern for the medication error. Resident stated she was okay.
And what is the effective date? This note.
February 16th, 2024 at 12:06.
And what is the created date?
February 17th, 2024 at 14:12.
So a couple of these notes have reference to neurons. Was there a neuro check form included when the facility provided you with these records?
No,
Were you able to see a neuro check form from another source?
yes.
I am handing you what's been marked as Case Exhibit 2. Can you tell me what this is?
This is the Indiana Department of Health survey note.
And how does the OAG get access to these notes?
We complete a form requesting the information, and then that form is sent to the State Department of Health.
And then the State Department of Health sends what they have.
Yes.
And what do the survey notes generally consist
information from the facility regarding different documents, as well as interviews of various individuals that were involved or could have been involved in the incident.
So I'm gonna have you turn to page 99. And can you tell me what this is?
A neurological checklist.
Is this for patient SJ?
Yes,
And are these checks signed by Ms. Montefiore?
yes.
What kind of symptoms do they show?
They record blood pressure, pulse, respiratory rate, if she was easily aroused, pearl, normal reflexes, and hand grips.
Now, we were just looking at the patient record, and we could see an effective date and a recorded date. Is that right?
Yes,
For this document, is there a way to verify when this document was created?
You can object as to speculation.
I would argue that, Ms. Smith's experience reviewing medical records directly informs her opinion about this.
Cool.
So did the surveyors conduct interviews?
yes.
You have you turn to page 20. And have you look at the very last paragraph on the page. Are those notes from the surveyor's interview with Ms. Martinez?
Yes,
The survey and patient records stated that there was a medication error, but neither described how that happened. According to these notes, how did Ms. Martinez say that the medication error?
And again, I would object. Read them, well, it doesn't matter, withdrawn, go ahead. Withdrawn.
during the interview, she indicated that on February 16th, 2024, at 8 a.m., she was packing medications and accidentally gave SJ another resident's dose of MS Cotton. She said that she had it out for another resident who asked to take it later, so she put the pill into the cart on top of a med cup with SJ's med in it.
And according to these notes, did Ms. Martinez notice SJ exhibiting any symptoms throughout her shift?
No,
I'm going to take you back to page 23. But first, did the surveyors interview anyone else about SJ possibly exhibiting symptoms?
yes,
So I'm going to take you to page 23. Halfway through the page, there's an interview, the paragraph starts 11:45 a.m. Who was interviewed
the resident's roommate.
and what did the roommate observe?
She indicated
Objection, hearsay.
Please continue.
She indicated that she was still very upset and stated it was just awful and she was sad about what had happened. She said on Friday before lunch, her roommate started spitting up and making gagging noises. She said the nurse had stood outside their room looking in at the resident who sat in her wheelchair. Behind the resident's pulled curtain, she stated she liked to keep it closed partway. After lunch, her roommate kept spitting up and was making gurgling noises. She put on her call light and yelled for staff to check on her. She said a nurse came in later into the room and told her not to worry about it. And the roommate stated she felt like she was put in her place, but the resident needed help. Then she was taken out of her room because the EMS came. She asked if she had ever heard the resident cough before, and she stated no. She really hadn't heard her do that and had never heard her gurgling and gagging like she had on Friday.
Very next interview, still on the same page. Looks like the surveyors talked to RN Zach Lewis. What did he say? Is it the same page?
That's not on the same page.
It's on page 24.
24, sorry.
He stated that he worked on February 16th, but was scheduled on another holiday. He said around 1:45 PM, Tina asked him to help her get SJ into bed. He helped her, but hadn't stayed after that. He heard her breath sound to be raspy, but hadn't heard coughing. Said Tina told him she had things under control and didn't need any more help, so he left and went back to his bed.
I'm gonna take you to page 25. Looks like the surveyor spoke to physical therapy assistant Karen Beth Schulman. What did she say?
Yeah, very bottom of 25.
She was interviewed and she stated that SJ had been receiving PT with her last treatment completed on 12/15 prior to lunch. She said she had shortened her treatment and just did wrong with her because she was complaining of being tired and nauseated. When asked, she said she had told Tina about her observations. She provided a copy of her therapy note, which indicated the resident's condition.
I'm gonna hand you what's been marked as State's Exhibit 4. And can you tell me what this is?
The coroner's report as well as the toxicology report.
And, I'm sorry, I should ask, was there an autopsy done on patient SJ?
Yes.
And who reviewed the findings?
F.R. Dellinger, who's the chief deputy coroner for Whitley County, and then Lindsay Emery, the pathologist.
Did they agree on, SJ's cause of death?
No,
What was the disagreement about?
whether the morphine had contributed to her death.
And what was the coroner's opinion?
He felt that during his conversation with the toxicologist, he was told that there are not established minimum levels of morphine that can be determined to cause death in people with compromised respiratory system. And while the resident's level was considered to be within a therapeutic range, in a normal person, SJ was not a normal patient.
And you sort of touched on it, but why did he think that SJ was not a normal patient?
Due to her diagnoses that she had with COPD and that she was on supplemental oxygen and had just a lot of respiratory diagnoses.
Why did the pathologist disagree?
She stated that while she understands the concern about the medication error and the proximity to her death, the morphine levels present in her system at the time of death were not lethal. She was in no distress in the immediate hours following the error, and unfortunately died 9 hours later.
So we've discussed the disagreements. What did these two professionals agree?
Both that her diagnoses, her prior diagnoses did contribute to her death.
I have no further questions for Ms. Smith.
Ms. Young, any questions for this witness?
Yeah,
I'll make sure you use your microphone.
Thank you. It's on. Sorry. I got raspy. I am getting over a cold, so I'm sorry. I'm gonna come from the end of your testimony up. Okay. So I want to talk about Exhibit 4, the coroner's report and the coroner's inquest and the actual postmortem report, okay? So page 1 of Exhibit 4 is the coroner's report, and that's an inquest, correct?